All right, welcome everyone. Thank you so much for attending our seminar today. My name is Amber Callahan. I'm the Chief Revenue Officer here at First Advantage, and I'm very excited. We've had such a great response on this topic today, and so we have several of you all here in person, and then we have many others online. So really great opportunity, and so thank you all for participating. I'm excited to introduce our speaker today. It's Jennifer Kahl. She is with Heritage Law. She is a Newport News native, and she has been an expert in this for over a decade. And so she's here to bring a wealth of knowledge and help educate us all on this topic, which is so important. We'll be taking questions throughout, so please let's make this interactive. And if you have a question, feel free to ask. And for those of you online, if you want to drop your questions in the chat, we will be sure to get those answered as well. So without further ado, I will now turn it over to Jennifer.
Thank you. Can everybody hear me? Good. All right. I know I can't see the people online, so I guess Message and Amber will let me know if there's something that needs to be fixed online. So yes, my name's Jennifer. I'm an attorney with the Heritage Law Group, and we specialize solely in estate planning and elder law. So that is things like your will and your power of attorney, and then related areas like guardianships for incapacitated adults, estate and trust administration, and getting qualified for Medicaid. So really anything that has to do with getting old or crazy or dead, that's what we do, right? all of those things together. So when they asked me to do this presentation, I had to think a little bit. I'm like, oh, okay, well, what should we talk about? Because there's a lot of avenues that we could go with this topic. It's pretty broad. But what I decided was kind of start at the beginning, because when most people walk into the attorney's office, they'll say, well, I need a will. Or they'll say, I think I need a will. I don't know. Do I need a will? But a will is the document that a lot of people are familiar with, where they're going to write down what's going to happen to their assets after they pass away. So I want to start with that, because there's actually a lot of misconceptions about what a will does and doesn't do. So we're going to start here, and we're kind of going to build to some different concepts. And you're welcome to ask questions as we go along. And we'll kind of start there. So do you want to go to the next slide? Oh, that's boring. There we go. Okay. So what your will does is it controls who's going to get what after you die. However, it only controls the assets that are in your estate. Okay. And I think that most of us, when we think of that term casually, we think of our estate as just being everything, right? Everything I own. And a lot of people, when they write a will, that is their assumption that this will that they're going to write is going to apply to everything that they own. But in reality, the technical definition of what your estate actually is much narrower than many people realize. And this leads to a very high percentage of the problems that I deal with is because the person who wrote the will wrote one thing thinking that the will was going to do something that it actually doesn't do. Okay, so what we're going to do now is we're going to define what the estate is. So your will controls the estate. What is the estate? Okay, so go to the next slide. Figuring out what is in your estate is really a process of elimination. So what we're going to do is we're going to eliminate all the things that are not part of your estate. And then at the end, whatever is left, that is your estate, and that is what your will controls. Okay, so first, anything that is jointly owned with another living person is not part of your estate. If you die and you own an account jointly with another person, it's just going to belong to the surviving owner, right? So if you're married and you have a joint account and one of you dies, that's kind of logical, right? You think, oh yeah, of course it's going to belong to my spouse. Where I see this cause a lot more problems is, let's say that I have become elderly and I realize that my health is declining and that I'm going to maybe need some help with my finances. And so I pick my daughter who lives near me and I add her as a joint owner on my bank account to help me with my finances. But I have 3 other children, and in my will, I have put that everything goes to my 4 children equally. Well, if I pass away and I have one daughter on my jointly owned account, who's going to get that account? The daughter. The daughter is going to get the account. And what are the other kids going to say? They're going to say, well, that's not what it said in the will. And they're going to come to my office and they're going to be really mad. And they're going to say, well, my sister isn't following the will. And I'm going to tell her, sorry, the will doesn't apply because the will only addresses estate assets and a jointly owned account is not part of the estate. Now, where this gets confusing is that there are multiple ways that two people can be on a bank account together, right? And this is another issue that can often bring up some confusion because I could say I'm on mom's bank account, and that could mean a variety of things. It could mean that I'm actually a joint owner. It could mean that maybe I'm just on there as a power of attorney, which does not convey ownership. It could be that I'm on there as POD, which just means I'm going to get it when she dies. I could be on there in just some sort of signer's capacity that doesn't convey ownership. So it's really important, first of all, if you're considering adding someone to your account, that you understand the consequences and you understand the options of the various ways to add someone to your account. And on the flip side, if you are the family member of somebody, you want to make sure that you understand how you're on the account and what the repercussions of that will be. So item 1, jointly owned assets, they go to the surviving owner. They are not part of the estate. Questions up to this point? Pretty basic. Okay. So next we get to assets with a beneficiary designation. I will often ask a family, I'll say, okay, so dad died. Does this account have a beneficiary? And they say, well, yeah, the will says the beneficiaries. I'm like, no. The actual account, right? Like if I have an account with First Advantage, does First Advantage have in their records who the beneficiary is? That's what a beneficiary designation is. It's when the company that holds the account has in their records who, here, come on in, who it's supposed to go to when they die, okay? And synonyms of beneficiary designation that you'll sometimes see on accounts are POD, which means payable on death, or TOD, which means transfer on death. Good. So if you see TOD or POD or beneficiary designation, they all mean the same things. It's a financial institution's way of designating who this is going to go to when they pass away, right? So if an asset has a beneficiary designation, who gets it? The beneficiary that's named. What if the person on my life insurance policy is actually my ex-husband and I never updated my beneficiary designation? He'll still get it, right? And if the will says something totally different, doesn't matter, okay? Beneficiary designation trumps whatever the will says. Also, we're assuming the beneficiary you've named is alive, right? A living beneficiary. If they're dead, then that's another issue. But so things with a beneficiary designation, they are going to go to the person to whom they're designated. Questions about that part? Pretty straightforward. Okay. Next, we have if the person happens to have a trust, if there are assets that are actually titled in the name of the trust, well, those are going to pass pursuant to the trust and also don't have anything to do with the estate. Now, to understand what it means to be titled in the name of the trust, that means like if I actually look at the bank statement, it says the owner on the statement is the Smith Family Trust, right? It doesn't say John Smith, right? It says it actually has the name of the trust on the account itself. Or if I'm looking at the deed to the house, that it actually says on the deed, it says the Smith Family Trust. A lot of times people are confused because I'll say, oh, I see dad has a trust. Well, is anything titled in it? And they're like, well, I don't know. Like here's the, have you seen those big binders that lawyers give you? They push that big binder and they say, well, I don't know, it's probably in there somewhere. And I say, no. The trust document doesn't tell me what is in a trust, right? In the same way that if you have a business and I read your articles of incorporation, is that going to tell me how much money your business has? No, your articles of incorporation just set up your business. To figure out what's in the business, we have to look at how the bank accounts are titled, right? To see if they're actually titled in the name of the business. It's the same way with a trust. The trust document just sets up the trust, and then it depends on what the person has actually titled in the name of the trust to figure out what's in the trust. Okay. So what this means is if I have a trust, and I pass away, maybe I have 4 different bank accounts. Maybe 2 of them are actually titled in the name of the trust and 2 of them are not. Well, the 2 that are titled in the name of the trust, they're not going to be part of my estate because they're titled in the name of the trust. And maybe the 2 other accounts, if they don't have a joint owner and don't have a beneficiary designation, then they would be part of the estate.
Jennifer, I know you had mentioned that the beneficiary trumps the will, but does the trust, anything that has to do, this is a question online, does the trust trump the will?
Okay, so assets that are titled in the name of the trust, they're going to go to what the trust says, regardless of what the will says. So I guess in that way, you would say, yes, it trumps the will. However, if you have a trust, you probably have a will that is intentionally compatible with the trust. Typically, if you have a will and a trust, your will says, if I forgot to put something in my trust, right, meaning now it's in my estate, put it back in my trust. So usually your will is just going to reference your trust. So I guess you could say, yes, it trumps it in that way. But yes, if it's titled in the trust, it's going to do whatever it says to do with the trust. It doesn't matter what the will says. Okay. So to answer the question about what a will controls, it controls the stuff that doesn't have a surviving joint owner, that doesn't have a surviving beneficiary named, and that isn't in a trust. That is what is in your estate. So like I said, we kind of have to say what's not in the estate to define what is in the estate. And so when a family comes to me and somebody has passed away, this is the first thing I do. I kind of jot this out and we go through everything that the person owned, all their life insurance policies and their investments and their bank accounts and their houses and their royalties they're getting from the book they wrote or whatever, right? We go through all the assets that they own and we fit them into one of these categories and we say, okay, where does this fit? Because what we're trying to figure out is, what is the role of the will in this situation? A lot of times there's actually nothing at all in the estate and the will means nothing, right? So that's why, yes, it's important to have a will, but what's more important? How you title your assets, right? What happens a lot is that people will go to a lawyer and they'll say, I need a will. And the lawyer says, cool, I can write a will. What do you want your will to say? And they say, well, this is what I want my will to say. And the lawyer says, great. And they write out those things and they give them the will and they walk out the door and they go, everything's great, right? Are we sure that what it says in the will is going to happen? No, right? That will could end up being completely irrelevant based on how that person has their assets titled. Another thing that people often think is that whether or not you have a will dictates whether or not you go to probate, right? Everybody's heard of probate and it's just this terrible, awful thing. And a lot of people say, well, oh, if you have a will, you don't go to probate. And if you don't have a will, you do go to probate. That's absolutely not true. Whether or not you have a will has nothing to do with whether or not you go to probate, okay? Whether or not you have to go through a probate process depends on how much is in your estate and what type of asset it is, okay? Typically, if the assets in this estate, not counting real property, is over $50,000, that's usually when we're going through formal probate proceedings, okay? So maybe I'm sitting down with the family and maybe we have a couple accounts that have joint owners and we have a couple accounts that have a beneficiary designation, but we have this one life insurance policy that had dad listed as the beneficiary, but dad actually died 10 years ago. She never updated the beneficiary designation. So now we look at it as though there is no beneficiary designation. That means now that insurance policy is in the estate. The policy is $75,000. Well, now we are going to have to probate just that insurance policy, right? We don't probate all this other stuff because it just does what it's doing. But the part that's in the estate, we're going to have to probate that. And like I said, that has nothing to do with whether or not there's a will. If there is a will, then the will control what happens to the estate. And if there's not a will, whatever fell into that estate bubble will be controlled by the laws of intestacy of Virginia, which say, you know, if you're married, it goes to your spouse or your kids or whoever, right? A lot of people, they say, oh, I need to write a will so the government doesn't get my money. Like, okay, the government's not going to get your money, even if you don't have a will, but it's still good to do it. All right, so
another quick question
yes.
from online. Well, actually two. So on the topic of real estate, someone is asking, how do you keep a home from going into probate and go directly to your children if you and your spouse pass?
Great question. What's the other one?
The other one is just, is it more important to have, sorry, I just lost it. So what's better, having a trust or will, or do you need both?
Okay. Let's go. Do I have a slide? Okay, let's go to, actually go to the next slide. I'll get to both those questions in a second. Okay, this just kind of reiterates what we just said. The assets in the estate are the only assets that go to probate. Oh, here's another thing. Lots of people, they spend all this time, who's my executor going to be? Is it going to be this kid, or is it going to hurt this person's feelings? Whatever. Again, if you have no estate assets, who your executor is doesn't matter, right? The executor is only in control of the estate assets. So I have a lot of family members, they'll come in and say, well, look, I'm the executor named in the will, so I'm in charge of everything. And then I say, well, yes, you're in charge of the estate and there's nothing in the estate. So congratulations, you're in charge of nothing, right? There's no assets in the estate. You are irrelevant, right? They don't like that when I tell them that. So the executor only controls the assets that are part of the estate. Like we said, the terms of the will or the laws of intestacy only apply to the estate assets. And in general, creditors only have claim to the estate assets, right? So if you die and you owe a whole bunch of different people money, but you have no money in your estate because you put beneficiary designations on everything, guess what? Your kids don't really have to pay them. They can just go unpaid. It is technically possible for them to pursue other assets, but it's very difficult. And so usually they just write it off. Okay. Okay, then you can see down here, okay, real estate. You can see my little star, except real estate. It has its own rules. Okay, so let's talk about that because I think that's the next slide. Is real estate. There we go. Okay. Real estate, meaning land, houses. That's what we mean when we say real estate or real property. That's your house, right? In Virginia, the default rule is that real estate passes outside of probate. It just skips probate. That's very unusual. It is not like that in most states. Why is that like that here? Because in Virginia, we still think we're in like the 15th century in England or something. Okay, this is vestige of English common law is why we have this. And it's just weird. Most states aren't like this, but it's just how we do it here. What that means is that if we were doing our little analysis, often the house doesn't have a beneficiary designation or doesn't have a joint owner and it's not in a trust. So you go, okay, it's in the estate bubble, right? So that means it's going to go through probate. No, actually it doesn't. It just skips probate and it just automatically becomes owned by whoever the heirs are, meaning the people named in the will or the default people who would get it by the laws of intestacy. So let's say that I pass away peacefully in my sleep at midnight and I have a will that says everything goes to my 4 children and nobody knows I'm dead yet, right? Nobody's found me. Certainly the court doesn't know that I'm dead yet. Certainly there's nothing on the court that says that my 4 children now own the house. But guess what? It's just magic. They just do, right? The moment I die, magic that happens in Virginia just says that my kids just own the house. They just do. It doesn't matter that there's nothing in the court that says that. It doesn't even matter that, like I said, nobody even knows I'm dead, but they just do. That means that the executor usually has no say over the house, no control over the house. My kids are just four people who own a house together, right? Now, often that can be really convenient, right? Most of the time we don't like probate. And so it's nice. Hey, we skipped probate. That's great. Sometimes if my four kids get along, that's really great. If my four kids don't get along, them owning a house together is a recipe for disaster, right? Because they're going to argue about whose turn it is to pay which utility and who paid the property taxes and should we sell it or should we rent it anyway. But that is the default rule. That's what happens, right? It just falls to the owners. In law school, they told us that it falls like a rock. Like, that's the weirdest analogy, but they say it falls like a rock, meaning it goes straight from the owner and it falls like a rock onto the heads of the beneficiaries, which to me seems a little morbid of an analogy, but that's what they say.
I have a quick question from
Yes.
online. I think you hit on this, but I just want to make sure. So if a home without a lien is deeded upon death, is there any value in placing it in a trust? I think you just spoke through that, but anything else to add?
Okay, so the question is, since real property just skips probate anyway, then what's the point of putting it in a trust? Well, the answer is that a lot of times you don't need to put it in a trust. If your goal is to avoid probate, you don't need a trust to avoid probate with your property in Virginia. That's not the case in other states. In a lot of other states, people make trusts all the time just to stick their houses in them to avoid probate. However, depending on your situation, there may be another reason that it makes sense to put it in a trust. Like I said, if my four kids aren't going to get along and them owning the house together is just going to be this prolonged conflict for like 2 years before they can, start acting like adults and actually sell it. My four kids aren't adults in case, yeah, they're babies, but my future kids when they're adults, right? They're of course going to get along great, right? They're going to be great. They're going to be angels. But a lot of times kids aren't like that. And so you may put the house in the trust and give the trustee the direction to sell the house and then just give the money to the kids, right? That avoids having four people own a house together and then they just can get the money at the end of the day. Or the realistic situation right now, my four little children are babies. Is it a good idea for babies to own houses? No. No, right? Because how would anybody sell the house or do anything? They're babies. They can't sign legal documents. So my husband and I do have a trust so that if we were to pass away, somebody else can manage those assets until the time that my children would be old enough to manage them themselves, right? Or what if I had a disabled child, right? I don't want my disabled child to inherit a house. Okay, so there's lots of reasons to have a trust. People always say, is a trust better than a will? We don't have, we only have like an hour, so we won't go into all that. But in general, what I would say is a will is a tool and a trust is a tool. And whichever one is better depends on what job you're trying to do. Is a hammer better than a screwdriver? Not if you're trying to screw in a screw, right? It depends on what you're trying to get done. And so when you meet with an attorney, whoever it is you're meeting with, that should be something that you discuss. What's my situation? What are my goals? What's the most efficient way to get from A to B? That may involve a trust or it may not, right? If you have one child and that adult, non-disabled, non-incarcerated, non-drug addict child, right? Then maybe maybe you don't need a trust because you can just allow the house to naturally fall to them outside of probate and they're good, right? It just depends on the situation. She said, so if you don't have children. Okay, so in my example, I've just been saying children since for many people, those are who they pick as their heirs. Obviously, in your will, you can name anybody you want. So if in your will you've named your sister, then the house just goes to your sister outside of probate. Or if you've named a charity. Now that's a little complicated because charities usually don't like to own houses. They want money, right? So that's another reason maybe you'd put it in a trust so the trustee could sell and then give the money to the charity. But yeah, it would work. If you have no will and no trust and no children, the laws of intestacy start going. They say, okay, well then to your parents, or if you don't have parents, siblings, or if your siblings are dead, to your nieces and nephews, and it just goes up the family tree, right? I have one estate right now where a man passed away without a will with a couple $1 million worth of assets, and his closest really living relatives, we had to get on ancestry.com to find them, and it's like these 41 distant cousins that never even heard of it, right? That's not a great situation. So that's a really good situation where you want a will, right? So that we don't have to go find your 41 cousins on ancestry.com.
I have two more questions online related to to property. Does putting your home in a trust protect you if you need to go into a long-term care facility? And then secondly, what happens if you gifted the deed on the property to one of the children, or you have created a TOD for one of your children?
Okay, I'm going to answer the second question first. So the second question is, like, if I'm alive and I added my child to the deed with me, it would depend on the wording of the deed. If it says that we're going to be joint owners with the right of survivorship, then that home would fall into that first category, the one that said joint ownership, right? Because it's joint ownership with survivorship, right? If I add my child to the deed and just say tenants in common, that has no survivorship, then my child continues to own their half, and then my half would pass pursuant to my will, right? And then a TOD deed, that's a transfer on death deed. That's essentially the same as putting a beneficiary designation on your house, right? So you can put a deed that says, when I die, the house goes to this person. That's not the same as adding them on it now, because they don't own it with me now. They're only going to own it when I die. And I could actually change that deed if I wanted, right? It's just like a beneficiary designation. So yes, having a joint owner on the house and having a TOD deed, that takes it out of the estate. And then the second question was Medicaid. Again, that's like another 3-hour conversation, but just to answer it really briefly, 99% of the time, the answer is no. A trust is not going to protect your house from Medicaid. It's not because a trust can't do that. There are certain types of trusts that can protect your property from creditors, including nursing homes, right? But those trusts are incredibly restrictive, and so most people don't do them. Your everyday run-of-the-mill trust that your neighbor has, that's called a revocable living trust. It offers no creditor protection and no protection for Medicaid or nursing home or anything. So yes, you can have a trust that offers that protection, but it's very uncommon because there's a lot of downsides to them, and people usually just don't do them because of the negative aspects of those. Yes, I hope I said Medicaid. If I said Medicare, I misspoke. Yeah, so Medicare is an entitlement, meaning when you all reach that magic age, you just get it, right? Zuckerberg, the billionaire Facebook guy, right? When he gets old enough, he's going to get Medicare. It doesn't matter how much money you have. Medicaid is the one that you can only get if you're impoverished. And so when people apply for Medicaid, if they have too much stuff, then Medicaid is sometimes going to deny them. And so when people are talking about protecting their house from Medicaid, what they're really saying is making it so that Medicaid won't count their house as an asset and thus deny them. Medicaid doesn't come and like take your stuff. They just say, sorry, no, we're not going to cover you, right? So there are things that we can do with houses other than trusts to try to help in that situation, but I'm not going to go too far down that rabbit hole right now. Okay, so back to what we were talking about. We were talking about the will and how real estate figures into all of that. Oh, so we'd said that in general, your executor does not have power over your house. You can word your will in such a way that the executor does, though. Like you could specifically say in your will, you could say, actually, yes, I give my executor power to sell my house, and I direct my executor to sell my house and put the proceeds in my estate and distribute them to my beneficiaries. So if you say that specifically, then it can. Interestingly enough, in Virginia, title companies require incredible specificity to say that the executor actually has power to sell. If it's just something kind of vague like, oh, I give my executor all the statutory powers, including this power and this power and this power, oh, and the power to sell, title companies aren't going to let that transaction go through, which in my opinion is stupid, but it has to be incredibly specific. Like there's no other way you can interpret that. Then the executor can have power to sell. Also, if you have debts, or if the decedent has debts that can't be satisfied with other assets, then that is also a situation where the property can be brought into the estate to be sold and paid the creditors. However, that is not the default. Somebody has to take specific action to make that happen. So like in the scenario where the person dies and has no estate, but they have debts, they could have a house and the house goes to their kids, and the kids are coming to me and saying, well, are the creditors going to come after us for the house? And my answer to that would be, yes, they could, but they would have to take specific legal action to do that. And it's not necessarily an easy thing for them to do. And so they never do it. Like never, like not in the 10 years that I've been practicing in this have I ever seen a creditor do that. And that's typically because people don't owe one creditor enough money to make it worth that creditor's time, right? They may have 10 different credit cards that all have $15,000 on it, right? But it's not worth it to any one credit card company to really work that hard for their $15,000, so they just write it off. So the answer, they could, but they usually don't. Now, sometimes as the family, though, for whatever reason, you do want to get everything settled out, right? I won't go into too many examples there, but sometimes they want to. In that situation, it's entirely possible for the person who's named as the executor to initiate that and say, as the executor, I'm going to become the executor and I'm going to petition the court and say, hey, court, I need power to sell the real estate because there's these debts that need to get paid. And the judge will always approve that petition. So it is easier for the family to sell the house to pay creditors than it is for the creditors to sell the house to pay creditors, right? So typically, unless the family wants the house to be subject to the debts, it's usually not going to be.
Questions in the chat.
Okay.
They're a little specific as far as scenario. So if real estate is deeded to 4 children and 2 have passed, and the wife of the deceased sibling is paying the taxes, does she have any say? And then the second one, if there's a will, one child has lifetime rights and one child's supposed to help with bills and taxes on the house. After the lifetime right person passes away, does the house go to the one paying the bills? What if she doesn't want to live in the house? The lifetime right person doesn't want to live in the house. Hope that makes sense.
Okay, the broad rule here, if you are trying to claim some sort of extra ownership over a house because you've been the person paying the bills, that's not going to work. Okay, you could have been paying the real estate taxes for the past 20 years. That's going to have no say on your ownership of it. So in general, this, well, I've been paying the taxes or I've been paying the bills isn't going to matter. In the first scenario where the question had to do with, is the sibling's spouse going to have some ownership in the house? It all depends on the wording of the deeds. So for example, if I left my house to my 4 children and I died, now my 4 children own the house. What each of my children does with their quarter is up to them. One of my children could have a will that says when I die, everything goes to my husband. And if she still owns 1/4 of the house when she dies, then yes, my cousin or her husband has inherited that quarter, right? That's because it's her quarter and she can do whatever she wants with it. Now, if I've given my house to my kids in such a way where it's survivorship between them, where I said I give it to my 4 kids with the rights of survivorship, then that's going to mean that if one of them dies, it's just the survivors who own it. And so which husband is going to get it? The husband of whichever kid lives the longest, right? Whichever kid lives the longest is now going to own the whole house, and she's going to die to go to her husband, right? So I don't know if that really specifically answers all those specific questions, but in general, ownership is all going to be about the exact wording in the deeds and the order in which people died, and none of that has anything to do with who's been paying the taxes. Okay, let's go to the next slide. Oh, Here's some examples. I don't know that we need to go through these in detail because we've kind of been doing that as we've gone along. Just kind of what I've been trying to lay out for you is the thought process that I'm going through whenever I'm analyzing a situation like this. So like I said, if the family's coming to me because dad just died, I'm going through this whole analysis with dad's assets, right? I'm going, okay, this is going to pass by joint ownership. This is going to pass because it has a beneficiary designation on. He does or he doesn't have a trust. And okay, this is in the estate. And is there enough in the estate that we need to go to probate? And, so that's what I'm doing. If I'm sitting with a family who's you're still alive, right? And you're saying, I want to do my estate planning, then I'm kind of doing the same thing. I'm going to ask you every single thing that you own. And then I'm going to ask you what you want the end goal to be. And then I'm going to figure out the most efficient way to get each thing where you want it to go, right? I'm not just going to write a blanket will and walk out the door. I'm going to look at this and say, okay, you have an IRA. Oh, beneficiary designation wins every day with an IRA, unless your intended beneficiary is a minor or disabled. For tax reasons, that's easy. We're always going to put a beneficiary designation on the IRA, and it's not going to have anything to do with the will, right? And then maybe I'll look at your bank accounts and say, okay, well, this is the best way for this to pass. And we'll look at your house. And this is where I'm going to ask you about who your intended beneficiaries are and if they get along, right? We're going to decide, is it okay for these people to inherit the house together and then work together to sort it out? Or do we need to have some sort of specific direction that an executor or a trustee is going to sell it, right? So then we'll figure out how we're going to deal with the house. And then after we've kind of done all that, then we're going to say, okay, now given our plan for each of your assets, what should the will say, right? A lot of times, because we're wanting to avoid probate, we assume that the will is actually going to control fairly little. Sometimes we're looking at the will just to kind of sweep up the little stuff, right? Your knick-knack collection and anything that we forgot to put the beneficiary designation on. And so the will might say something really simple like, oh yeah, whatever's left, just give it to the kids. But we've done that in our minds, knowing that the will is almost kind of like the plan B, because we've already discussed how we're going to transfer everything else. Does that make sense? Maybe said a different way, a will get your stuff where it needs to be, but it might not get it there the most efficient way. So as we're strategizing what to do with your estate, we want to go through each of your different assets and say, okay, how are we going to get it there and how are we going to get it there in the most efficient way? Questions? Yes. Mm-hmm. Yeah. It depends on how I leave it to my children. So for those online, her question was, if you leave land to two children and one of them, okay, I understand. What you're saying is if the will says something general like, I leave this to my kids, is the assumption that it is with survivorship, or if is the assumption that it's tenants in common? The legal assumption is that there is no survivorship, right? So almost always when property is left to siblings, there is no survivorship between the siblings, because that's the default rule. You have to be really specific and say there is survivorship, and most people don't say that. So typically, I leave it to my two kids or however many kids you have. Each of them owns their little fraction, and they can do with their fraction whatever they want to do. They can write a will that leaves their fraction to your son-in-law that you hate, or, whatever. In general, siblings owning real estate is not a great idea, right? Because even if the current siblings get along great, how do we know that the next people who are going to inherit are going to get along? This is what happens is the 4 siblings die and each of them had 4 kids. How many people own the house now? Now there's 16 people who own the house together, right? This is a recipe for disaster. A lot of times when you see vacant buildings and or vacant homes and you're like, that's a nice home. Why isn't anybody there or what? Lots of times it's because it's owned by 15 different cousins and they can't figure out what to do with it, right? It's a title issue. She said, is that considered heir property? I mean, the term heir property doesn't have any technical meaning, but I guess you could say, yeah, it's owned by the heirs. But when you have multiple people owning a house and then those people die and those people die, you can see how over the course of a couple generations, now you have way too many people owning property. I know that a lot of times people come to me and they have this kind of idealistic vision that, I would just, this is kind of the homestead and the kids were raised here and they bring the grandkids here. And I really want the home to stay here so that all the kids, they can gather here and it'll be like a vacation home. And that's a great idea. I get it. My parents have a little farm, right? And I would love for that farm to be there for generations. In reality, it is often very, very difficult to do that because for all the reasons that I've mentioned, is who's going to bear the costs of it? Who's going to settle disputes that arise between the siblings? Who's going to mow the lawn and who's going to pay the taxes? And what if you both want to use it the same weekend? And then you die and now there's more owners. And so a lot of times even though that's a nice sentiment and I understand that, in reality, it doesn't work that well. If you really want that to happen, you probably just are going to have to pick one kid who you trust and leave it to them and hope that they'll share it with the others, because legally anything else is usually going to create a really challenging situation. Sorry, I'm getting over a cough from last week and I'm still have a little bit of a frog in my throat.
So I did have some more online as well. So great question. That's almost that identical question was online. So thanks for answering that. But then also we had one, they're looking for some clarity for the best way to protect their home from Medicaid in the event they do need to go into a nursing home one day. And then also the second one is, does the beneficiary designated work for the TSP? The TSP, is it the same as it would an IRA?
Yes, that one's easy. Yes, a TSP, an IRA, a 401k, a tax qualified annuity, all of those accounts where you put your money in now and you pay taxes later. Beneficiary designation is usually the best way to handle those. Because that gives your recipients the best tax options. That said, there's always reasons not to do that. Like I said, with my own children, do I want my 4 kids who are babies to inherit my IRA? Well, no, that doesn't make any sense. So I actually am directing that to my trust. Well, first to my husband. My husband is the primary beneficiary. The trust is the alternate beneficiary. That way a trustee can manage it for them if we pass away. And yes, that works for a TSP, any of those accounts that have letters with, that works for that.
So a question similar in that same topic came in. So same for insurance policies for minor children should be put into a trust instead of the beneficiary listed as a child.
Yes. Okay. Insurance policies are a little bit less complicated though, because they don't have the same tax complications that those other accounts have. And so whereas with an IRA, we hardly ever put it into a trust. With life insurance, we put life insurance in a trust all the time because it doesn't have any negative tax consequences to do so. But yes, if we the beneficiaries on my life insurance policy are primary to my husband, alternate to my children. Again, because I don't want minor children inheriting all that money directly. They need to be older before they're able to manage it. Oh, Medicaid. Okay, then the question about how do you protect your home from Medicaid? I mean, how much time do I have? I mean, I don't and there, okay, I'm only gonna briefly put this. Okay, if you want to protect anything from Medicaid, and again, when we say protecting it from Medicaid, it's not that Medicaid is going to come to your house and steal your stuff, right? Medicaid doesn't come and take your stuff. Medicaid just declines to cover you, right? Medicaid says, sorry, you don't qualify. You need to find some other way to pay the nursing home bill. Does the nursing home come and take your stuff? No, the nursing home doesn't come and steal your house or anything, but they are going to send you a bill, right? And if you have run out of other money to pay that nursing home bill with, sometimes people do have to resort to selling their homes just to continue paying the nursing home. But just realize the government is not taking your money. The nursing home is not taking your money. It's just that Medicaid is declining to cover you. And so you may need to tap into some of those resources that you were hoping you wouldn't have to spend, right? So if the question is, how do I arrange my assets such that I could qualify for Medicaid without having to get rid of stuff? That's really what you're asking. You're asking, how can I make it so that these assets aren't countable for Medicaid? So that if I need nursing home care and I don't want to pay for it, and I want Medicaid to pay for it, how can I make it so that I can more easily qualify for Medicaid and not have to spend down these resources? The answer to that question is any of the strategies that we have involve you giving up control of your stuff. Okay. And I'm not going to go into all the details of the ways that you do that, but you cannot own your stuff completely. Well, in most cases, you can't own something completely and not have it counted for Medicaid. And so all strategies are going to involve you giving up some level of control over your stuff. Maybe we're going to transfer things into the name of your kids, or maybe we are going to do a Medicaid protective trust, or maybe we're going to do a life estate deed with your house and add your kids to it. There's a lot of different strategies. Just realize that every single one of those involves you giving up control of your assets and control of your stuff. And so I counsel regularly with families about this topic. And it's always a balance. Some people say, yeah, I don't mind. Sure, give everything to my kids. I don't mind like giving up control of my stuff. I want to know that this money will be saved if I need Medicaid. Great. Other people are like, yeah, you're going to pry my stuff out of my cold, dead hands. No way I'm giving this to my kid, right? They're saying, well, fine, I'll just use it to pay for the nursing home if I need it, right? So whenever we're talking about Medicaid protection, we're always having to balance those two goals and figure out what is more important to you. Is it more important that you feel that you have autonomous control over your assets as long as possible? Or is it more important to you that you may be eligible for Medicaid someday in the future? Again, realizing that whether or not you're even going to need Medicaid is, we don't know, right? So yes, there are things that you can do to plan ahead for Medicaid. Absolutely. Most of those strategies need to be done at least 5 years in advance. So that's the other thing. You have to give up control of your stuff when you're still fine, which is a hard pill for some people to swallow. So those are options, but I'm not going to go into all the detailed strategies right now. Okay, next slide. Let's see what else I have up here. Oh, okay. Now that you know all this great stuff about what a will controls, how do you write a good will, right? How do you write a will that's going to work? I would say my number one suggestion is to keep it as simple as possible, right? Please don't leave $1,000 to 25 different people, right? A lot of times people are like, oh, but I want somebody to know that I love them and that they're not forgotten, so I want to mention them. From a legal standpoint, the more people you mention in your will, the more complicated the whole process becomes. Actually, just this morning, I talked to a family where the house was the only thing in the estate. So typically we'd say, great, the house passes to the kids, no probate. But in their will, they had said that $5,000 goes to this charity. That $5,000 is now messing up the whole thing because really the kids own the house less $5,000. And when they go to try and sell it, that gift to the charity is going to cast a shadow on their title. It'll make it harder for them to sell it. And so we're going to have to do some more creative things to kind of fix that issue. They're probably going to end up paying the charity with other money, and then getting them to sign a release saying that they give up any claim on the estate and all this. But wouldn't it have just been easier if mom and dad had just told the kids, hey, we trust you. After I die, will you give $5,000 to this charity? Or if they had just said, you know what, I'm just going to write a check this Christmas and call it good. That would have been so much easier. So often when people kind of put these little, I call them kind of like the feel good gifts. because they're just kind of, it's a small amount. It's not really changing the ultimate outcome that much, but it's really complicating things. So I would say avoid that. You want your will to be as simple as possible. And in general, you want to look at your will as plan B, because usually you're going to transfer your assets other ways that don't involve probate. And typically your beneficiary designations and your titling are going to be more important than your will anyway. Oh, this is just another quick note. I saw that I stuck on there. If you have charitable intent, like you want to leave money to charities, it is you, and if you have one of those accounts with letters, TSP, IRA, 401k, I'm missing a couple. Anyway, if you have any of those, it is usually far better to make your charity the direct beneficiary of that account rather than naming the charity in your will. And that's because, and I see this happen all the time, if they put the charitable intent in the will, then we end up paying the charity out of like the house or the life insurance. And then the kids get the IRA and the kids have to pay taxes on the IRA. If we give the charity the IRA, the charity doesn't have to pay taxes on the IRA. And now the kids can keep the money in the house, which aren't taxable anyway. See what I'm saying? So it's far better to give the charity assets that would otherwise be taxable, because then nobody has to pay the taxes, right? So if I really wanted to give $5,000 to the charity or some small gift, I could say that the charity is a 10% beneficiary on my IRA and the other 90% goes to my kids. Now I don't even have to mention it in the will, and it's better tax outcome for everybody. Okay, go to the next slide, please.
Few more questions online, but I will pause on, we'll get through the remainder of the presentation. And then if we've got time, we will stick around and answer them. So keep them coming.
Yeah. Okay. So I want to quickly get on my soapbox about how important a power of attorney is. So I have it on the slide. If you really can only afford one document, get a power of attorney rather than a will. And I say that a little tongue in cheek. Obviously, you should get a will too. But the most ugly messes that I've been involved with, it's way messier when we have problems and there's no power of attorney than a will. That's because the power, well, when does the will apply? When you're dead, right? So if it's a disaster, who cares? You're dead, right? You're dead. And people are fighting over stuff. And at the end of the day, whatever, it's stuff. A power of attorney applies while you're living, right? It says who's going to help you when you are your most vulnerable, when you are incapacitated, when you need somebody that you can trust with your money, to trust with your medical care, to make those important decisions for you. If that is a mess, the consequences are far more heartbreaking and far more messy, because now we're dealing with a human being, not just money and stuff, right? Now maybe we have kids in court litigating who gets guardianship over dad, right? And those are just, they are ugly, ugly, messy cases. So the power of attorney is where you say, if I can't manage my own affairs, then this person makes those decisions for me. If they're not available, then I name this person, etc. Right? You want to go to the next slide for me? I think I have a couple. Oh, common pitfalls. So you're like, great, I have a power of attorney. You want to make sure that the power of attorney is going to be adequate for your needs. Common pitfalls that I see with powers of attorney. Number one, that they don't name backup agents. They name one person, often their spouse. But I tell people, I say, well, when you are old and crazy, your spouse is probably going to be old and crazy too, right? So we should have somebody else there, right? Maybe a generation younger, right? So we want a couple people named so that we know we always will have somebody. Often the power of attorney doesn't address who can and can't review the actions of your agent. So that's a big question. If somebody is questioning what your agent is doing, who has the right to review those records, right? If I think that my brother is maybe doing something inappropriate with my mom's money, to what extent is he obligated to disclose to me, right? A power of attorney should address that. Sometimes power of attorneys have an expiration date. This is particularly with military power of attorneys. They're often only intended to serve during a deployment. And so they'll say, oh, I have a power of attorney. And I look at it, I'm like, well, yeah, it expired in 1982, right? That's not going to help you. And then finally, if it doesn't include all of the necessary powers for your situation, the logical person would look at a power of attorney that says, my agent can do anything for me that they need to do. And you would assume they can do what? Anything, right? Nope. Nope, they can't. Here, go to the next slide. There's actually a whole list of things that your agent cannot do for you unless they're specifically mentioned in the power of attorney. And I've named just a couple of them here. They can't do anything with your trust. They can't make gifts over a certain amount. Oh, it says 14. That's like 18 now. They can't change or create beneficiary designations. They can't delegate their authority to anybody else. They can't do things with your retirement benefits, exercise fiduciary powers on your behalf, buy U.S. savings bonds. That's super random. Why do we have to specifically say that you can buy U.S. savings bonds? I don't know. You do. Or access records of your electronic communications. And this is just an example of some of the things that your agent actually cannot do for you unless you specifically say they can. You may be looking at that list and go, oh, I don't know. I don't think my agent probably won't need to do those things for me. But I run into situations all the time where we actually do want to do some of these things on the list, particularly if we're planning for Medicaid. Planning for Medicaid involves a lot of weird stuff. And sometimes we do want to do some of the stuff on this list if we're getting somebody on Medicaid. And then sometimes we can't because the power of attorney isn't adequate. So that's my soapbox of how more people, I feel like the will gets more attention, but the power of attorney often ends up, in my opinion, being a lot more important. So you should, number one, make sure you have one. And then number two, make sure that it's adequate. Okay, questions. I think that's the last slide, and we've got like 5 more minutes, so maybe a couple questions.
Sure. Any questions from the room?
Okay, so the question was, when I'm talking about a power of attorney, am I talking about how does medical get in there? The most common thing is to have 2 powers of attorney, one for finances and legal and one for medical. There's no reason that they can't be together in one document, but standard practice is to separate them just because they have 2 different purposes, and you can name 2 different people in those roles. So yeah, you usually are going to want one for finances and one for medical. Good question. No, if all of your accounts, you could have $1 million. If the question was, if I have $50,000 and they're all POD, do I have to go through probate? The answer is no. You could have millions of dollars. If you have a POD designation on each one, it doesn't go through probate. It only goes to the person that you've named. Good question.
All right, so I've got some from online. Can you write into your trust or will that items that pass down to your children stay with your child if that child happens to marry and divorces, so that you're protecting the assets and ensure assets stay within the bloodline relatives only, being like those future grandchildren?
Let me answer that. So people often have this concern. They're like, oh my gosh, I hate my daughter-in-law so much, and I would just die a second time if I knew that my daughter-in-law was going to have my house, right? Yes, you can in some ways. Like you could put your stuff in a trust for perpetuity, forever, where you control with an iron fist everything that happens. You can. But you would, in that situation, you really would not be leaving the money to your son. You'd be leaving it to a trustee, someone other than your son, who would manage it to make sure that it only went to the son and not to the daughter, not to the daughter-in-law, the spouse. So yes, it is possible to put stuff in a way to ensure that the terrible spouse is never going to get the money. Most of the time, though, we realize that it's probably not worth it to try and exercise that level of control after the grave, right? In general, when you give people your stuff, they're just going to get it and they're going to do what they want to do with it, right? They're adults. They're going to do what they want to do with it. Most people can accept that. If you can't accept that, or if there are legitimate concerns, right? like we have substance abuse issues or disability issues. Now we have something like that, then I think a trust might be justified in that situation. But we always have to balance our desire to control things and people we don't like in our kids' marriages over the practicality of that. And I think maybe one more question.
Sure. So I just wanted to pause. So we are at 2, so I want to be mindful of everyone's time. So if you need to leave, feel free to drop from the online call or leave in person. But if Jennifer has time, we'd love to stick around and continue to answer some questions, if that's okay with you.
I'm happy to answer questions,
Okay.
but yeah, please don't, if you're bored, you're like, I'm done.
Yeah.
You can go.
And this, if everything worked as it should today, this was recorded. And so we will send out the recording and we will also send out a copy of the presentation.
Oh, and I will say, for the people online, I did have some handouts here, but they really are just articles that I printed from our website, thlgva.com. That stands for the Heritage Law Group Virginia.com. If you go to the articles tabs, I haven't written a whole lot lately, but there have been times when I've written quite extensively articles on these types of topics, and you can go look there. I often tell people, guys, I'm giving it away for free. It's all on there. So you're welcome to go and find the handouts there.
All right. So the next question has to do back with Medicaid. If they have gifted the deed of the house to their daughter, would the asset be safe from the Medicaid look back if they needed to go into that long-term care facility?
These people, I keep trying to get past Medicaid and they won't let me. They're like, we're going to make you talk about Medicaid. Okay. Yes. If you gift your house to your daughter, well, okay. When you apply for Medicaid, they ask if you've made any gifts in the last 5 years. So if I gift the house to my daughter and I apply for Medicaid in 3 years, then I would have to disclose that I had made the gift. And the result of that gift is that I'm going to be assessed a penalty, which is a period of time for which I'm disqualified from getting Medicaid. If I make the gift to my daughter and then I make it the 5 years and I apply for Medicaid 6 years later, then no, the house, in this sense, we'd say, yes, it's protected because the gift was more than 5 years ago and it's not in my name anymore. You just do have to be careful because often there are other consequences to gifting real estate. Your daughter may have to pay capital gains taxes when she sells it that she otherwise wouldn't have had if you'd owned it until the time you died. And anyway, yes, in general, gifting the house to your kid and then waiting 5 years, yes, it works for Medicaid. You just need to be careful because Medicaid is not the only goal, right? Sometimes we get tunnel vision. We have to make sure that this decision that we're making makes sense in the broader scheme of our estate plan and our tax plan.
Great, thanks. And so the next one is to confirm further understanding that houses and land do not have to be placed in a trust, but can be designated in a will as part of the estate.
Yes. And in Virginia, they will not go through probate. If you own real estate in other states other than Virginia, do not apply that. That is not the same in all states, but in Virginia, yes.
And then this person is asking if they are single and don't have a husband, is that when they would need to add a trustee to control the trust for their underage children?
Yes. If you're single and you have underage children, I would definitely recommend getting a trust because if you pass away, who's going to take care of the money for your kids? You would probably set up a trust where you named yourself as the primary trustee, and then you would have other trustees listed after you who could manage the assets if you became incapacitated or you passed away.
And then what's the best way to save on taxes during the transfer of ownership to beneficiary, TOD, or trust, home, life insurance, vehicle, IRA?
Okay, so most assets are not going to be taxed when you die. Obviously, if you have one of those letter accounts, TSP, IRA, 401k, whoever takes the money out will have to pay the taxes. So if you take the money out when you're alive, you have to pay income taxes on it. If your kids take it out after you die, they pay income taxes on it. There's nothing you can do about that. You can strategize the pace at which you take the money out, but there's no getting around that. Other than those accounts, everything else passes to your beneficiaries completely tax-free up to $13.6 million. Most of us don't have $13.6 million. So I would just say, don't worry about it, right? You have other problems. Estate taxes is not one of them. If you do have multiple millions of dollars, then we'd have another conversation.
Great. And then to confirm, so if an IRA has a beneficiary listed on it, it does not go through probate.
Correct.
Correct.
Yep.
Perfect. Let's see.
Can I take a question?
Sure. Oh, absolutely. I'm
Yeah.
sorry.
Yeah, so her question is, if you write a will, obviously things are going to change over time. So how do you address those changes? If you kind of think back to what we've talked about, my recommendation is to have a very simple will, and much of your disposition is going to be controlled by the titling of assets. This is another reason why I recommend that, because guess what? It's really easy and it's free to change your beneficiary designation. To change your will, you probably have to go see your lawyer and you probably have to pay them some money. It's a lot bigger deal. And so that's why if we're relying on titling to deal with most of our transitions, you don't even have to address that in the will, right? Now, there still may be situations where you do need to update your will. And typically we just rewrite the whole thing. It is possible to do a codicil to your will, which is an amendment to it, but I really don't like those just because I've had so many situations where the will and the codicil have gotten separated from one another and we can't find the other. And honestly, now that we have computers, it's not like, we are handwriting this or typewriting it. It's just easier to rewrite the whole thing and just have it in one document rather than have a codicil and a separate will. Other questions in the room?
Is there a time limit for trust assets to be distributed or the trust to be closed?
Yes, it has to be reasonable. Isn't that super clear? Yeah. Yeah. If you're a trustee, you have the obligation to execute the trust in a reasonable time frame. Obviously, that's super vague, but the truth is it just is totally dependent on the situation. If it's a really, really simple trust, then there's probably no reason it should take more than a year, right? Probably less than that. If this is a trust where we have really complex situations going on and tax issues and beneficiary issues, and, often it does take several years. And whether or not that is reasonable just depends on the situation. So I cannot give you an answer.
If real estate conveys immediately upon death to the heirs, how are those heirs designated? What's the definition for that?
So if you have a will, it's whoever is named in your will. And if you don't have a will, then it's the laws of intestacy in Virginia, which are going to name your, spouse or kids or the order. There's an order to that. Again, anybody who needs to leave, feel free. You don't have to stay for the entire. Oh, yes. Oh, thank you. Thank you.
All right. I think we're caught up online, but it looks like we have another question in the room.
Yeah, so she's saying that she has only one child, one heir, and she's saying, is there any advantage to giving this child gifts now rather than, I guess, her just getting it when you pass away? If you have more than $13.6 million, yes, right? People will they'll give that certain, $18,000 per person per year because they're trying to reduce how much is going to get taxed when they die. If you don't have that much money, then you don't need to do it for a tax reason. If you're trying to do Medicaid planning, usually you're not going to do that little bits at a time. You're going to do a big chunk all at once to get the 5-year clock ticking on that chunk. Otherwise, no, there's not really any need to slowly give gifts, and unless you want to, right? If that's something that makes you happy to help your daughter out and be giving her gifts, sure, that's fine. Just be aware that if you do end up needing Medicaid, all gifts within the last 5 years are on the table. Okay. Oh, okay. You're like, I know all about that. Okay. And then we'll do this one more question and then we'll dismiss. Okay. All right. The cost of making a will. Right. Okay. So if a single person were to come to my office and we were to do all the basic documents, a will, a financial power of attorney, a medical power of attorney, disposition of remains, and HIPAA release, that's usually what we do in a package for a single person. That would be $2,000. Now, my firm is a specialty firm that does this specifically. So there certainly are other places where you will find it for less than that. There also are firms in the area that are more than that. So I'd say we're kind of maybe average or maybe a little higher than average, just because that's our specialty. If you just were looking for a will, probably at our firm, I think it's like $800 for just the will. So I'd probably say, anywhere from a couple hundred to $1,000. Well, no, I said the will, the power of attorney, medical directives. Okay, so if you No, you don't always need the trust to go with the will, but I always recommend getting the power of attorney documents, whether or not you're getting a trust. If you're getting a trust, then you're going to be looking maybe between $3,000 to $5,000 for a trust. Yeah, sorry. Okay, so the question is, what should you have come in advance to the visit with me? So first of all, if you call and set up an appointment, we actually send you a letter that tells you everything to bring. So you're told everything to bring. But the biggest thing is just have an idea of what you want. You'd be amazed at how many people come to my office and ask for a will. And I say, who do you want to get your stuff when you die? And they go, oh, gee, that's a good question. How have you not thought about that if you made an appointment? So think about that before you come to see me. And then, yeah, we send you a letter that will tell you what you bring. Okay. I'll come and just answer your question personally. Is that okay? Okay. You've all been wonderful. I want to let you go so we don't go too far over. Thank you so much. I appreciate it.
Yes, thank you so much.
Okay.
And then we did have some questions online. For those of you that are interested in following back up with Jennifer, her contact information is up on the screen. And I also dropped a link in the chat to that webpage that she mentioned that also has her contact information. So thanks again for everyone for joining us today and have a wonderful afternoon.